Chapter 1. Foundations. Psychology and the legal field. The need for the intersect between legal matters and the field of psychology was perhaps evidenced through the birth of forensic psychology. This cross-disciplinary approach could be considered to be the use of psychological research, theories, practice, and treatment over a legal setting. Gonzalez-Sala et al., 2017. Additionally, the application of the scientific foundations of psychology in civil and criminal settings also provided the development of new techniques and procedures to particularly cater to the forensic field. Gonzalez-Sala et al., 2017. Some observations and studies that seeded the relevance of psychology in this legal arena stem from contributions regarding the use of witnesses and testimonies. Over a century ago, Wilhelm Stern provided insights as to the implications of memory relating to a witness's account, as well as practitioners becoming expert witnesses. Shah, Oman, and Van Koppen, 2013. Court system elements. The court system includes a wide range of professionals that are instrumental in both scientific stages and throughout the proceedings. Court system elements. The court system includes a wide range of professionals that are instrumental in both specific stages and throughout the proceedings. Several elements could be explored as means to provide a focus to its pertinent structures in the United States. The first aspect to consider is the federal nature of judicial processes. In this case, the central government of the nation carries the powers that the incorporated states cannot execute as inherent sovereignty. Melton, Petrilla, Pryrothras, and Slobogin, 2007. Therefore, the federal government receives its governance from the Senate and the House of Representatives, and it is modulated by the Supreme Court justices. Melton et al., 2007. Consequently, this element impacts the district court cases at the federal level, thus consisting of a superseding hierarchy when accounting for local and state law. The second element to consider is criminal adjudicative processes. As it relates to the federal district courts, an individual could be prosecuted giving an alleged violation of the law that could result in criminal punishment. Melton et al., 2007. In this regard, the prosecuting attorneys could be entrusted by the federal government to address which criminal offenses might be presented against a defendant. Melton et al., 2007. Element relationship. The relationship between forensic psychology and each of the previous elements of the court system could be conceptualized under a practitioner's roles. For instance, cases presented in district courts at the federal level could make use of forensic practitioners as evaluators. Here, the defense could request forensic practitioners to determine which, if any, mental health issues could have directly impacted the offense at hand. Melton et al., 2007. This process could be part of a possible plea, such as that of not guilty because of insanity. NGRI Melton et al., 2007. In this case, a practitioner could make use of medical, historical, criminal, Bonney and Slobogin, 1980, and assessment data as means to assist the judicial process in ascertaining if an NGRI resolution is warranted. This type of defense can later be contested by the prosecution, Bonney and Slobogin, 1980, which could result in yet another role for the practitioner in the criminal process. A forensic psychologist could be summoned as an expert witness. This type of role could be commonly found in criminal proceedings as recommended by both the defense and the prosecution. Bonney and Slobogin, 1980. While executing this role, expert witnesses could expect that prosecuting attorneys scrutinize their opinions as means to favor a potential conviction. Babitsky and Magravati, 2000. Working as an expert witness in a district court along with the prosecution might be appealing for several professional reasons. However, such a role in this setting implies a great familiarization with higher-order laws that might not generally be sought after in everyday practice. Further, the challenges that the expert role entails provide forensic practitioners with an ever-changing and complex arena. Psychology and the legal system. Given the array of subspecialties in general psychology, it is imperative to analyze how this field has contributed to branches outside the mental health setting. This is the case of general psychology as it is applied to the legal system. Some scholars argue that such application of psychology remains a topic of debate when considering its definition as a forensic concept. Some contend that applying general psychology concepts in a legal context inherently develops an intersection known as forensic psychology. Huss, 2001. Yet, other scholars argue that forensic psychology is not the sole application of general psychology knowledge, but rather it might refer to clinical practitioners executing their roles in a legal setting. Whether considering general or clinical applications, this can be identified in two areas: research and consultation in civil and criminal settings. Forensic psychology benchmarks. Overview. Despite its relatively recent development, it could be argued that forensic psychology has become a significant part of multiple areas. These influences have promoted the development of research and application for psychological practitioners and the interest of laypersons. This subfield's term was coined from judicial processes that took place in ancient Roman forums where dispute defenses occurred. Huss, 2001. In a similar fashion, forensic psychology could be broadly considered as the application of clinical knowledge in a legal setting. Huss, 2001. However, it is relevant to consider how psychological research and practice was ultimately applied in a law environment. One significant aspect of forensic psychology history is its potential origins. Researchers suggest that James McKean Cattell provided initial insights regarding testimonies during the second half of the 19th century. Bartol and Bartol, 2012. Here, Cattell made use of a student sample, where each was inquired to describe the weather conditions of that past week. Bartol and Bartol, 2012. The testimonies of the students varied drastically from one statement to the next. Bartol and Bartol, 2012. Notwithstanding the apparent simplicity and recent occurrence of events. A second significant aspect of forensic psychology benchmarks is its recent recognition as a particular subfield of psychology in the United States, with origins tracing back to the late 20th century. Evolving of the field. These historic benchmarks have provided significant contributions to the evolving field of forensic psychology. For instance, vast contributions have been provided when considering the capabilities to testify in a court of law. This topic of interest is currently studied in forensic research and applied during competency, individual selection, and witness evaluation by expert practitioners. One could argue that Cattell's rudimentary experiment provided a foundation for the present-day psychology applications in legal contexts. Concerning the historical recognition of forensic psychology as a subfield, the intermingling of psychological fields should be considered. Currently, the inclusions of other areas, such as developmental, social, and clinical fields, are not only included in forensic psychology guidelines, but are recognized as instrumental parts of its future. American Psychological Association, 2016b. The original application of general psychological concepts is currently emplaced in forensic psychology, but has evolved into an integrative approach with other fields and their contributions in legal arenas. Contribution impact. First, psychological research might significantly affect the legal setting by attempting to understand human behavior before its presentation in a legal context. For example, research might provide insights into how a person's lifespan development, personality, and risk factors might impact criminal behavior and its potential reoccurrence. The second application is the psychologist's consultation in a forensic context. This consultation can take the form of a psychologist conducting a clinical assessment, Huss, 2001, or as an expert witness, Bartol and Bartol, 2012, amongst others. For instance, a psychologist might provide an informed assessment of a relevant psychological illness, Huss, 2001, that affected the individual's ability to comprehend the civil or criminal accusation, Bartol and Bartol, 2012. Furthermore, psychological practitioners could provide expert testimony as means to determine potential future violent behavior, Huss, 2001. Consultation. Overview. The consultation of forensic psychology professionals is arguably as varied as the interests of its practitioners. Likewise, the need for specific forms of consultation also provides a highly diverse focus for consultation. Consequently, let us consider two forms practitioners could consider within these areas of forensic psychology consultation. The first type of consultation is records and transcript review. As this term implies, a legal party requests the services of the practitioner as means to conduct a review of multiple data sources, McKee, ND. In this case, historical documents could be part of the review to include previous medical and psychological reports, McKee, ND. Further, legal documents, such as transcripts and statements, could be part of the record review, McKee, ND. It must be noted that this form of consultation does not include direct contact with examinees, but rather records that might be part of their case, McKee, ND. Another form of consultation involves a specific type of work and population, the potential rehabilitation of juvenile defendants. The particular concept of the recognition of a separate type of court for juveniles originated from the pretense of their rehabilitation over punishment. Gottlieb and Coleman, 2012. In this regard, forensic practitioners could be asked to address the potentiality of treatment as it relates to a particular crime as conducted by the juvenile offender. Melton, Petrilla, Poitras, and Slobogan, 2007. Consultation challenges. Despite that these two forms of consultation spark some interest due to previous record analysis familiarity and target population, such duty might still present some challenges. For example, one difficulty concerning the area of forensic psychology consultation records and transcript review revolves around possible ethical concerns. It could be argued that inexperience might elicit faulty or far-fetched conclusions that extend beyond the scope of the documents at hand. On the same token, an inexperienced forensic psychology consultant might fail to recognize emergent issues of a record review. These other areas of examination could include recognition signs of the defendant's limited ability in regards to their competency to confess, McKee, ND. Careful record analysis and cross-referencing with collateral information, such as pretrial document review, Moses, 2001, could be used to limit such deficiencies. A specific concern regarding juveniles is the enhanced possibility of an examinee faking good or faking bad as it relates to symptoms, Melton et al., 2007, that could affect treatment recommendations. To maximize the impact of this challenge, consultants should make use of instruments that specifically cater to this population while incorporating scales or instruments of malingering. Consultation breakdown. Given a variety of factors, perhaps due to experience or ingenuousness, individuals who wish to become forensic psychology practitioners could be drawn to specific areas of consultation. For example, an area of forensic psychology consultation of interest is the two techniques of interviewing and interrogation. These law enforcement-centered procedures involve the utilization of attempting to discern which statement might be false and later facilitate obtainment of confessions, respectively. Casson et al., 2010. As such, it is appealing to study, evaluate, and analyze such processes, not from the viewpoint of an interviewer, but rather as a consultant. The second area of interest involves the area of jury selection. This aspect consists of the elimination of individuals that might not be deemed fit to possibly execute a verdict in a specific case. Hutson, 2007. This consultation subject field is appealing given a variety of reasons. First, jury selection methods of elimination could spark the appeal of aspiring forensic professionals, as it is a form of forensic practice where the examinees are not facing trial, but rather potentially imparting a trial themselves. It could be argued that many commonly attributed methods of consultation revolve around the stereotypical assumption that practitioners most often address defendants. Lastly, addressing other individuals performing civil duties might also translate into an underlying civil duty service at the end by the practitioner. Jury selection. There are civil and criminal court cases that might be resolved with the sole involvement of legal professionals. Yet, there are other instances that laypersons might be called upon to address the verdicts of the remaining cases. This need then calls for the inclusion of a jury of the defendant's peers. Hutson, 2007. Jury selection is the process used which discerns among individuals that are the fittest to address a specific case. As it could be derived given the myriad of factors that should be accounted for in this process, multiple resources should be explored. Forming forensic psychology practitioners could be encouraged to make use of means to become knowledgeable and skilled in this area. For example, one historical piece of resource to consider is that developed by Richard Christie, 1976. Christie's work included the first means to include demographics to ascertain characteristics for potential jurors. Christie, 1976. Concerning research regarding the scientific foundations for jury selection, there are pieces of literature that are available and currently endorsed by the American Psychological Association. This description fits that of literature review conducted by Joel Lieberman and Bruce Sales, 2006. The work is aimed at a compilation of historical and present literature as a means to assist forensic psychology consultants and legal professionals concerning jury selection. Lieberman and Sales, 2006. Likewise, another resource available is training programs for students that wish to follow a forensic psychology career path. For instance, depending on state laws, students who are currently pursuing a doctorate in philosophy, Ph.D., in psychology or a doctorate in psychology, PsyD, could earn a forensic psychology specialization. This, as well as similar programs, provide an opportunity to gain a specific focus in forensic psychology, which can include risk and cognitive assessment, tests and measurements, and the practice of psychology in the court system. Lastly, students and forensic practitioners alike can gain knowledge of other resources in the form of conferences. These sessions are comprised of seminars, such as the foundations and intricacies of the role of consulting and assisting in the jury selection process. American Psychology Law Society, 2016. Overall, each resource provides a complementary approach to gain insights for jury selection consultation. Consultation preparation. Expertise process. Before a forensic practitioner can become an expert, there are multiple steps to consider. The process to become an expert in each of these areas could initially require an interest recognition stemming from the practitioner. Later, it might be significantly relevant to identify the present need of these areas of expertise. This identification could include both regional necessity and current subfields that are seeking the expertise of a practitioner. Next, aspiring experts should become more familiar with the many different requirements that might credit the individuals with meeting the standards of expertise. These provisions could include specific curriculum expectations, internship, specialized training, licensing, postdoctoral preparation, and ethical standards compliance. Indeed, psychologists might commonly practice consultation in specific fields ranging from cases involving business law, Hutson, 2007, to capital offenses, communicating psychological concepts and their impacts to laypersons, Pittle et al., N.D., and law enforcement, Kaysen et al., 2010, should be a matter of consultation expertise as they relate to a given case. As such, these matters should be included in the expertise development process. Issues with consultation. The impacts of forensic psychology towards the legal system could be observed in one of the following roles practitioners can execute. Consultation. As noted previously, this role consists of tasks such as providing expert testimony, Gottlieb and Coleman, 2012, conducting evaluations and assisting lawyers in the jury selection process, Melton, Petrilla, Poitras, and Slobogin, 2007. However, each of these skilled duties can pose ethical, legal, and practical issues and considerations for professionals. For instance, the necessary skill level, training, and expertise required for conducting expert witness role demands high standards and correspondingly similar remuneration. McKee, N.D. As a result, this type of compensation could be presented as a concern by legal parties. Babitsky and Magravati, 2000. later to be conceptualized as an ethical violation or issue. Another issue could be present when conducting evaluations of an examinee. However, the field of forensic psychology, given its relatively new development, might not count with extensive literature to support some evaluations. Schumann, Cunningham, Connell, and Reed, 2003, thus becoming a potential legal violation. Lastly, it has been argued that while working for an attorney, during the jury selection stage, practitioners could be exposed to a practice issue. In this regard, attorneys might deem that practitioners who aided the jury selection process might also serve in another consultant task in the same case. Melton et al., 2007. Importance of concerns. Given the challenges these issues and concerns might provide to forensic psychology practitioners, it is relevant to discuss their importance. For example, it could be argued that if the compensation concern is not adequately addressed, then upcoming testimony and its preceding credibility might be put in jeopardy. As such, regardless of which level of expertise was used to achieve expert opinions, its value could be reduced for those who were granted access to its development. Conversely, lack of empirical support to conduct evaluations could be equally as inadequate. It has been noted that the mechanisms leading to testimony, such as how data is collected, should be substantiated by vindicated scientific foundations. Gottlieb and Coleman, 2012. Lastly, executing multiple consulting roles after duty selection might also put subsequent work at risk, since it could be a significant source of bias. Melton et al., 2007. Needs for subspecialties. After the relevance and use of psychological science in the field, professional organizations began the recognition of forensic psychology under its own merit. Edkins et al., 2017. However, the application of this field has extended beyond the mere use of behavioral science knowledge in a legal arena and general consultation. Rather, despite its recent development, forensic psychology has become an integral part of the legal process through implementation in multiple legal settings. As such, this text is set in providing a brief overview of the main subspecialties in which forensic psychology has been divided and the roles of forensic psychologists. In some instances, I will compare federal laws with the nation's first state in alphabetical order, Alabama, among others, as means to provide a comparison of the two levels of statutes. Readers are encouraged to consider how their local and national laws also impact the practice of forensic psychologists. I will present the interesting challenges and key topics that complete the field of forensic psychology.